Good day, everyone. I'm going to share to you the alternative dispute resolution and its relevance to BS criminology. Conflict is inherent in society. It evolved from physical combat to structured resolution via courts or neutrals, or mediators, arbitrators, or negotiators. Because conflict is inherent in society, much effort has been expended by men and institutions in devising ways of resolving the same. Let's discuss the historical trends of this alternative dispute resolution. Judicial and legislative focus on alternatives to court trials were meant to address delays. And we can see here some key legislations on addressing delays in the justice system. First, we have provisions in the Civil Code of the Philippines, or Republic Act 386, effective in 1950. There are provisions in this law on compromises and arbitrations to encourage fair settlements among disputing parties. We had also Republic Act 876, or the arbitration law, in 1953 to supplement the Civil Code. And this law promotes arbitration without revoking prior provisions in the Civil Code. And dispute resolution has also an international mechanism. We have right now the United Nations Convention on Recognition and Enforcement of Foreign Arbitral Awards, and it has reciprocal recognition for international disputes, and UN Central Model Law was the Philippines commit to the UN Central Model Law to adopt it in the domestic legal context. That is why the Philippines employs arbitration, mediation, conciliation, because that is in consonance to the United Nations Convention on Recognition and Enforcement of Foreign Arbitral Awards. Because not all legal conflicts occur within the domestic or within the Philippines only, but there are contracts, for example, between entities in the Philippines and international entities like suppliers of equipment, and these conflicts can be resolved through arbitration. For example, if the Philippine National Police procures firearms from Turkey or a corporation from Turkey, that contract, the contract between them, has arbitral mechanisms or arbitration mechanisms, and that is governed by the United Nations Convention on Recognition and Enforcement of Foreign Arbitral Awards. What are, because it continues to challenge the Philippines, what are the challenges that led to the promotion of alternative dispute resolution? Number one, we have congested court dockets. We have so many cases in our court system. New cases, in particular, outnumber resolutions due to limited judges and other challenges in the court. And the result, there is delay in the delivery of justice in the Philippines. And that is so unfortunate. We need alternative mechanisms to fast track or to comply with the speedy disposition of cases provision under the Constitution of the Philippines. So what was the response of the judiciary or the Supreme Court? It has now enacted pretrial conferences in its rules, modes of discovery, anti-forum shopping rules, small claims procedure, judicial affidavits instead of oral testimony, direct testimony. There we have now judicial affidavit rules and continuous trials of criminal and as well as civil cases. The aim of this is to fast track cases, to decongest our court dockets. And the emphasis is on mediation and judicial dispute resolution. And the Supreme Court encourages compromises and arbitration to declog courts and settle disputes expeditiously. The court is encouraging disputing parties first to go to the barangay if it is within the jurisdiction of the barangay justice system. If not, then go to the courts. But during the pre-trial conference, the court, or after that, the court will order or refer the case to mediation. If not, then there is an alternative for judicial dispute resolution, which we are going to discuss later. So the court or the Supreme Court encourages alternative dispute resolution methods such as arbitration, mediation, negotiation, and conciliation. Arbitration is considered as the wave of future resolution of international disputes. It is the future of resolving international disputes. As I said earlier, as an example, if a Philippine entity like the Philippine National Police purchases some firearms from a corporation in other countries, their contract should contain an arbitration clause wherein they will resolve first their conflict through an arbitrator. What are the legislative action or the works of the Congress to address the problem on the clogging of courts? So to promote alternative dispute resolution, we have these laws. We have one, labor code. So we have National Labor Relations Commission that handles arbitration for labor disputes like unfair labor practices or termination cases of employees. So employees have a resort either to go to DOLE or they go to the NLRC and the labor arbiters. We have also provisions in the local government code. We discussed this before in our previous lesson, the barangay justice system. It mandates barangay level conciliation or mediation via pangkat ng tagapagkasundo before resorting to court processes. So it is condition precedent in the courts for cases that are covered under the barangay justice system. They cannot, the court cannot exercise its function to decide a particular case which is within the jurisdiction of the barangay if the barangay has not yet conducted mediation and conciliation of the disputing parties. It has roots in the Presidential Decree 1508, the System for Amicable Barangay Settlements. Then what did the executive branch also do to contribute to the promotion of alternative dispute resolution? It has enacted also several key legislations like the legislation to establish the Construction Industry Arbitration Commission. So if the construction industry players like contractors have problems with their clients, then their conflicts will not be brought immediately to the courts, but it shall undergo arbitration before the Construction Industry Arbitration Commission. Then we have also rules on alternative dispute resolution for disputes between national government agencies. So if one government agency, for example, the Department of Finance or the Bureau of Customs, or other government agencies like the Philippine Ports Authority, if it has a dispute with the Bureau of Customs or the BIR, Bureau of Internal Revenue for taxes, then that should be resolved first by the or through the dispute resolution involving government agencies. Now let's talk about the Alternative Dispute Resolution Act of 2004 or Republic Act 9285. It is considered as the comprehensive law institutionalizing alternative dispute resolution in the Philippines, and it became effective in April 2004. It covers arbitration, mediation, conciliation, early neutral evaluation, mini trial, or combinations. Arbitration involves an arbitrator who judges the case and evaluates the evidence. Mediation, it involves a person who acts like a communicator between the two parties and will try to encourage the parties to reach a particular settlement or a compromise. And the mediator give his does not give suggestions on what to do. That's the work of the mediator, just to facilitate the communication and understanding between the parties. For conciliation, conciliation is the conciliator acts also as a communicator between the two disputing parties, but a conciliator can provide remedies. He can suggest remedies, what to do, how to do it, what are the concessions between the parties, what are the alternatives. But he cannot judge. He does not determine the evidence in conciliation. Then this law also adopts the United Nations Convention, the UNCITRAL model law for international commercial arbitration. So like I said earlier, there are contracts that are international in nature, wherein one entity in the Philippines and another in other countries. Their contract is governed by this by their contract is governed by their arbitration clause that they provide in their contract. And the Philippines, because of this law, becomes a venue for international arbitration also. What are the features of Republic Act 9285? Here, the regional trial court refers to arbitration. No jurisdiction if arbitration clause exists. So if the contract between disputing parties says that they cannot go to court without first undergoing arbitration, the court, the MTC, RTC, has no jurisdiction to decide on the particular case. They need to comply with the provisions of their contract on the arbitration clauses. Then foreign awards confirmed by RTC. There are times that the arbitration will be conducted in another country, like for example Singapore. To enforce the award in Singapore, arbitral award in Singapore, the winning party, if the losing party is in the Philippines, so the winning party is in Singapore or another country, the winning party shall go to the Philippines and file the petition that before the RTC to confirm the foreign award, arbitral award, because the arbitration award, is not automatically to be executed. It needs an order from our courts to affirm or to confirm the award, and so that the court will issue a writ of execution. So it's not automatic. If there is arbitration award and that is to be executed immediately, no, it should be confirmed first by our trial courts or the RTC, I mean. The RTC jurisdiction to review can set aside or vacate on the UNCITRAL grounds. For example, if the arbitration court that handled the dispute had no jurisdiction, there was lack of due process, then our court, the RTC, the Regional Trial Court, because this is the only court that can confirm foreign awards, arbitration awards, can nullify the arbitration award. If there was no due process, there was no notice on the parties, and there was no jurisdiction on the part of the arbitral court in other country, then the RTC can nullify it, can set aside the arbitral award. What is alternative dispute resolution? We have the broad definition. It is considered as a system to resolve conflicts outside court trials using lawful methods approved by parties. So as I said earlier, in alternative dispute resolution, parties should not go first. If they enact it in their contract, they should not go first to the courts. they should comply with their contract to resort to mediation, conciliation, or arbitration, as the case may be. So, this system, the alternative dispute system, is very broad. It covers civil cases, labor cases, um, administrative cases handled by our administrative agencies, and no, not criminal cases. Oh, some criminal cases, like in the barangay justice system, they handle some criminal cases. Those that have has imposable penalty of not exceeding 1 year, and those that have possible fine of not more than a certain amount, then they go first to the barangay justice system. So it is very broad. But in the Alternative Dispute Resolution Act, the definition in the Alternative Dispute Resolution Act is limited. Under this act, alternative dispute resolution is considered as a process with neutral third party assisting resolution. And this definition excludes quasi-judicial agencies like the National Labor Relations Commission. National Labor Relations Commission, or the labor arbiters, they arbitrate labor disputes. And this is not covered by the ADR law or the ADR Act. But the broad definition of the ADR includes labor disputes. But under the law and in ADR Act, it does not include quasi-judicial. It has separate law for the National Labor Relations Commission or the labor disputes. It has separate law. We have the labor code for that matter. And here are not covered by ADR Act proceedings in the agencies like DOLE, as I said earlier, Department of Labor and Employment, the Intellectual Property Office, so for disputes on copyrights, patents, or insurance commission. So they are governed by specific laws. So ADR does not cover them. What is the state policy on ADR? The state aims to promote party autonomy. In ADR, alternative dispute resolution, conciliation, mediation, the parties themselves will agree on what to do with their case. So it's not the judge who will decide what should be, who is uh, who is at fault, who is wrong. So it's not the judge who will determine it. It's not the judge who will say that, oh, party A, you pay this, party B, you do this. So the parties themselves in ADR, they are the ones who have the autonomy, they have the free will, they have the choice, they are independent of the courts, and they determine what to do with their dispute. And the state also encourages ADR use for speedy, impartial justice and declogging of dockets. It's very important because the courts should be able to focus on more severe issues or more serious issues, severe crimes, severe disputes, compared to disputes that can be arbitrated or that can be easily mediated or conciliated in order to declog dockets. And it contributes to the speedy disposition of cases under the Constitution. And it involves private sector involvement, not only government. So it enlists participation in settlements. And the policy of the Supreme Court, ADRs like arbitration, mediation for amicable, efficient, and efficient solution. So amicable meaning friendly, not not combative, but friendly manner of resolving conflicts. Because when you go to court and you do not resort to mediation, conciliation, in court it is adversarial. You have an opponent. So the resolution of the conflict in the courts through trial, it is adversarial. You have an opponent and there is enmity between you. So even if the judge will provide a decision, the friendly relation between the parties is not restored or may not be restored. What are the principles of ADR? Party autonomy and self-determination. I said that earlier. That there is autonomy between the disputing parties. They decide what to do with their case, what is the method, and who will mediate, conciliate, or arbitrate the case. Then, efficient alternative tool separate from court system. so it is not prone to delays because the parties choose their mediators. Then for there is private sector participation that is a growing trend in various fields to help the justice system resolve conflicts um, faster than how the courts do it. Then the objectives and benefits of ADR is speedy, impartial justice, tool for inexpensive, amicable settlements. Going to court is expensive. It is tedious. It is combative. There is enmity. It is adversarial. But if you go to mediation, you mediate the conflicts in a contract and other disputes. Then there is amicable settlement. There's friendly settlement, and it declogs court dockets. So it works alongside trials to maximize efficiency in the justice system in the country. What are the features of ADR? First, it resolves disputes. It aims for final conclusion, not delays. So the output of mediation or arbitration is final, if not rebutted by any party, or if the party will not nullify the settlement or the agreement or the award. So it becomes final, and it employs lawful methods under the law like arbitration, mediation, etc., or combinations among them. It's not contrary to law, morals, or public policy, and it is contractual in nature. So if there is conciliation, mediation, arbitration, the agreement there or the award there is like a contract between the disputing parties that they will comply, or they should comply, or they shall comply with the terms of the agreement. It's like a contract between them. It can be enforced by the courts if the other party will not comply to the agreement. So it is like a contract. Then it avoids court trial, and it is independent alternative to litigation in court. What are the forms of ADR? We have arbitration, mediation, conciliation, neutral evaluation, mini trial, and combinations of these. Uh, Mini trial, as I already discussed earlier about arbitration, mediation, conciliation, neutral evaluation. Mini trial is like summary in nature. It's just a mini trial, not a full-blown trial between the disputing parties. It's like a trial, but not formalized in courts. So so we have arbitration, voluntary, renders binding award, because the arbitrator, as I said earlier, it provides the judgment in the dispute. Whereas mediation, voluntary, and facilitates agreement. The mediator as like a communicator, facilitator between the parties. The mediator does not provide solutions, does not suggest solutions to the parties. In conciliation, there is friendly settlement, and the conciliator, the one who conciliates the parties, will try to suggest, the remedy of the disputing parties. So he can suggest, unlike in the mediation, the mediator cannot suggest alternatives, but conciliator, he can provide the remedies, or he can suggest to the parties what to do. So features and objectives of ADR: it resolves disputes without going to court. It uses legal methods, contractual in nature. It avoids trial, and there is a neutral party, no, other than the two disputing parties. So there is a third party who will try to arbitrate, mediate, conciliate. Then the objectives are speedy justice and declogging of courts. And it has classification as two parties, like bi or multilateral alternative dispute resolution. There are two parties or multiple parties. And in terms of issues, there is simple issue or complex issue. So like simple issue, one issue only, but in complex there are multiple issues that is difficult to resolve by the two parties, disputing parties. And the conclusion is either complete or partial. So the arbitration can be, or the conciliation, mediation, the agreement or the award in arbitration may be in full, or it touches the full, the all issues in the dispute, or it can only resolve, it can also resolve partially the dispute. So and later and while the or while the arbitration continues, or the mediation continues for other issues. So it can be partial also. So partial agreement or award. Classification of ADR forms as to evidence, evidentiary. So that's arbitration. It involves evidence. The arbitrator will look into the evidence and he will decide who is right or is wrong. Versus non-evidentiary, like mediation, conciliation. These are non-evidentiary. The mediator will not try to look into the evidence and decide who is wrong or who is right. As to court case, it can be case related, like court annex mediation. So if the case is already filed in the court after the failure of the mediation, conciliation, like for example in the barangay justice system, and the case is filed already in the court can still refer the case to the court annexed mediator or the Philippine Mediation Center, who have court annexed mediators. Or the alternative dispute resolution can be independent from the court. As I said earlier, the parties to the dispute, depending on the area of the dispute, like for example, the dispute is on the copyright, so they go to the intellectual property office and they have mediators, accredited mediators by the intellectual property office. If the dispute is on electricity related, so they have also accredited the government agency in charge for that has accredited mediators also, and other agencies also. So it's independent from court processes. As to law, yeah, either domestic, international, or foreign. Domestic, if the parties are in the Philippines and do not adopt international or foreign law. If the parties to a contract, for example, are located in different countries, like one in the Philippines, as said earlier, the Philippine National Police will procure or buy firearms from a company in Turkey. So they will agree on the arbitration clause and they will agree on what law will govern their contract. So for example, if they agree that it is an international law, so they should put that in their contract. If they agree, however, that the law that should govern their contract is the Philippine law, then they put that in the contract. Or Singapore law, so that is a third party, then they can put it in their contract also. As to law, and we have also components, we have parties and the types of disputes, the alternative dispute form, and the provider of the alternative dispute resolution. Here are the subject matters of ADR. As a general rule, all disputes amenable to ADR except exclusions. So here, civil status, marriage validity, they cannot be subjected to alternative dispute resolution. There should be no compromise on civil status of a person, whether he is married or not married, whether he's single, widow, or not. Then whether the marriage is void, whether the marriage should be annulled, whether whether a spouse is psychologically incapacitated, whether there should be legal separation, and who has the custody of the child. That should not be compromised. It cannot be. It cannot undergo alternative dispute resolution. In other words, it is against public policy to negotiate or to mediate or to conciliate these disputes. So other exclusions include future legitimate criminal liability, like in rape, homicide, other crimes that cannot be mediated or conciliated or arbitrated. Non-compromisable issues, they are not covered by the alternative dispute resolution. Labor disputes also are covered by the labor code and not by alternative dispute resolution act. So they have different mechanisms. So what is the seat and venue of alternative dispute resolution? The seat is the jurisdiction under which proceeding is conducted. Venue is the actual site, and it may differ from the seat. Jurisdiction, like for example, the Philippine National Police is in the Philippines and the corporation is in Turkey. They have a contract buying firearms. The jurisdiction of the alternative dispute resolution covers Turkey and the Philippines. So that's the seat. But the venue of alternative dispute resolution can be in Singapore. So the jurisdiction of alternative dispute resolution covers two countries, Turkey and the Philippines. But the actual alternative dispute resolution, the mediation or conciliation or the arbitration, the arbitration is in Singapore, for example. So the venue is in Singapore, but the seat or the jurisdiction is the Philippines and Turkey. Basic concepts, concluding acts like awards, agreements, and other that are not forms of ADR. So other concepts in the lesson. So the awards and the agreements are considered as concluding acts. The award is a concluding arbitral award is the concluding act of the arbitration. The settlement is a concluding act of the mediation and conciliation. And there are other forms that are not ADR, considered ADR under law, but ADR as a system includes labor disputes and other mediation conciliation outside the ADR system. We have the international law, we discussed this earlier, the UN Citral Model Law and Foreign Award Recognition. The forms, arbitration, mediation, conciliation, evaluation, mini-trial combinations or combinations among them. Then classification, bilateral, multi-party, some simple, complex, or complete or partial award, simple or complex issues. Then bilateral and multi-parties, we discussed that earlier. How about the nature of ADR in terms of the information gathered there? Well, gathered in the ADR or information, confidential information in the ADR. They are considered as confidential nature. And the confidentiality of the information during the ADR, the mediation conciliation, the recognition of the confidential can be expressed, written, or declared, or implied. So it's not written or declared, but it is implied that all information there, especially material matter in the dispute, they are confidential information and cannot be used by any party against the other party or by another person against the disputing parties. If a party in a mediation will say that, I admit I stole your Carabao. If he says that, I admit I stole your chicken, that information, that admission cannot be used in court because that is confidential in nature. So legal effects. So any party may refuse to disclose. The mediator can refuse to disclose the information to the court. The arbitrator may refuse to disclose any information they gathered in court, or any party, they can refuse to disclose any information to the court. And they are inadmissible in proceedings. They cannot be accepted by the court as evidence. And the person involved cannot be compelled to testify in court. But there are exemptions like agreements and records and public sessions, because these are public in nature. So if they agree, they sign the agreement, that agreement or that award, if they accede to the award, they sign it, is not part of the confidential information. Here are the concluding acts in ADR. We discussed this earlier, the mediated agreements, compromises, waivers, or quit claims. So the product of mediation, conciliation, we call them as mediated agreements. So the parties will sign this to conform as a sign of conformity to the agreement. Compromises, then in conciliation, then waivers and quit claims. Waivers and quit claims. The parties here um, will sign the waiver or quit claim that they will not pursue the issue in courts. So after arriving at a settlement, what are the effects? One effect is res judicata. What does it mean? Meaning, if there is already an agreement, then after the reglementary period, there's no nullification of the agreement. Any party cannot file a case containing the same issue as that mediated already or resolved already, because that mediated agreement, compromise, or quit claim acts as res judicata. It bars the filing of another case in court having the same issue or having identical issue or similar issue as to the one that was previously mediated or conciliated. Then the agreement or the award is enforceable after approval by the parties or the arbitral or arbitration uh, or the arbitrator. Then the mediation, for example, in the court, it suspends trials. So the court, after the preliminary conference or pre-trial, it will refer the case to the court annex mediation, and that referral will suspend the trial of the case. So the court will wait for the result of the mediation. Alternative dispute resolution providers. So we have accredited mediators, I said this earlier, or arbitrators. So there are different agencies who have different mandates. They accredit mediators in the Philippines. So if you have a dispute, you go there. If your issue is covered by this agency, they have accredited mediators, and those mediators you just choose. The two parties will choose who among them who will mediate or conciliate or arbitrate the case. Then the liability, same as public officers. The mediators and arbitrators, same as public officers. So if they are in bad faith or malice or negligence, administrative cases or criminal cases can be filed against them as if they are public officers who committed malfeasance, or nonfeasance. ADR is encouraged and in the Philippines. However, if one party, for example, is a victim of threat and he just acceded to the agreement because he was threatened, then he can file a petition to nullify any proceedings or the voluntary agreement between the parties. Then mediation under the ADR Act, mediation, voluntary process with facilitator, exclusion court annex mediation, and JDR, which we are going to discuss later, because these are the cases under this, the court annex mediation and JDR, they're already filed in court. But in ADR, the cases are not yet filed in court. So classification, non-merit based and institutional or ad hoc. Non-merit based for ADR, like in the barangay mediation conciliation, is not non-merit based, meaning, in other words, not based on evidence. So the mediation is not will not tackle or will not discuss evidence. We will not look into the evidence, but the mediator will try to convince the parties to arrive at a settlement, not based on evidence but based on amicable settlement. It can also be institutional or ad hoc. Ad hoc, like a flexible mediation when the parties will choose their mediator. So it is an ad hoc in nature or institutional. The institution itself has mediators, then the mediator will try to, or the arbitrator will try to arbitrate the dispute. What are the stages in mediation? We have opening. So the mediator will have an opening statement, then the narration of the facts between parties, exchange between them, proposals, then summary, evaluation, and closure. The advantages of mediation is that it has confidentiality. They can air out their grievances against the other party, and those information are confidential. There is prompt resolution because there is no clogging of dockets among mediators. Then there is autonomy between the parties. They decide their fate. There is confidentiality, is privilege, and the information is inadmissible in court. Privilege meaning confidential. They cannot be used against another party. Confidential info like communication, statements, and pleadings, or the answer, the complaint, they are confidential. So it cannot be used against the other party in court. The effects refuse the any party or the mediator, the conciliator, they can refuse to testify in court, and the information is inadmissible in court also. They cannot be compelled to testify in court. Then the mediator privilege, they cannot report or testify. The mediator cannot report it to the court, cannot file a case between based on the information he gathered against any party. He cannot testify in court also. But there are exemptions to confidentiality like threats. So during the mediation, if one party threatens another party, that's a crime. So that's not included in the confidentiality rule. Abuse of claims, professional misconduct of the mediators, and so on and so forth. Court proceedings for crimes and felonies, they are not confidential in nature. The mediator, the principles in mediation rooted in fair play. The mediator should be fair. He should be impartial. The parties select mediator with freedom or party autonomy. So the parties themselves will choose among the available mediators, accredited mediators. So the party are considered as autonomous. They have the freedom to choose who will decide their case, or who will help them resolve their case. What are grounds for mediator withdrawal? Unable to act, parties select another mediator, or there are grounds include party request. The other party will request that the mediator will withdraw from the case because of perceived bias, lack of qualifications, or issues on impartiality. As I said earlier, bias, ethical violations, safety concerns. So these are factors that may lead to mediator withdrawal. So he will be replaced by another mediator. What are the duties of mediator? Of the mediator: maintain competence, disclose qualifications, and ensure impartiality. The mediator can also charge reasonable fees. So he will use his time. So he will lose a lot of his time. So these are the mediators can charge fees, except government mediators because they have their salaries or allowances. But accredited mediators, private mediators, they charge reasonable fees for the mediation because he will use his time. Yes, he's an independent mediator. So disclose basis, return on earned fees, no contingent fees to maintain impartiality. So the mediator cannot initiate a contract among the parties that he will retain a certain portion of the award, for example, or the settlement award, for example. So no contingent fees. That if one party will win, the mediator will have a share of that, and so on and so forth. So just reasonable fees. Duties during mediation: ensure confidentiality, promote consent, self-determination, encourage respect, and prevent abuse among the parties. So the mediator should inculcate peace, amicable settlement, peaceful, amicable settlement, not through quarreling, not through bias. So he should prevent abuse. The mediated settlement agreements, this is a concluding document, so it is a contract between the parties. Then it has res judicata effect, meaning, I discussed this earlier, the res judicata effect is that the agreement will be a basis to bar another party to file a case in court if the agreement was not nullified. If the agreement was not nullified within 10 days or 5 days, depending on, so within the reglementary period or within the period to nullify the award or the agreement, then the parties will be bound by the award or the settlement agreement. If one party does not comply with the agreement, then the award or the settlement shall be enforced by the court. So the party, the winning party, or the agreed party can go to court and ask the court for the enforcement order or the writ of execution. What are the principles in settlement agreement? Agreement prepared by the parties, so counsels or mediator, signed and certified, deposited with the RTC is optional. Deposit to RTC is optional but needed for enforcement if the other party will not comply. So deposit to the RTC for the RTC to issue the writ of execution. The enforcement petition to the same RTC, then the parties may agree to treat as arbitral award under RA 876, the arbitration law in the Philippines. Then the role of the counsel, collaborate for mutual advantage and assist in participation and comprehension. The counsel or the lawyer will not be in a combative stance. He should be like a consultant to his clients or to her client. So he will not be combative. There will be no adversarial acts done by lawyers. They should be friendly with another lawyer, or the other party will try to counsel, advise them. The party can consult with the lawyer, collaborate for mutual advantage, and assist the party in arriving at a settlement. So lawyers will act as advisors or consultants, less directive role, and help clients understand the process and benefits. So the lawyers will have less directive role, meaning they should not dictate how should the parties resolve the case, but they can give advice to the parties. Functions, discuss issues, prioritize resolutions, understand the other side, gather facts, explore options, and consider alternatives to agreement. Then it also assists in the drafting of compromise agreements. So it's important that the lawyer, if you have a lawyer, that he will draft the compromise agreement. If not, but you can also draft your own compromise agreement if you can. So what is arbitration? Let's have an introduction on arbitration. Arbitration is defined as voluntary process with arbitrators rendering awards, distinguished from court trials. So it is different from a court trial. So the arbitrator is chosen by the disputing parties, and the arbitrator will award the arbitration award, and the arbitrator will base his decision, the decision that awards, or the arbitral award, he will base it on the evidence presented by the parties. So it is merit based, unlike in mediation and conciliation. What are the kinds of arbitration? We have voluntary and compulsory. Voluntary, so as I said earlier, if two parties in a contract decide that they will have an arbitration clause in their contract, they can choose the arbitrator that can arbitrate their dispute. So it's not from the government, but accredited by the government. Whereas in compulsory arbitration, we have government arbitrators. So government mandated, like the labor arbiters. So if there is a dispute between the employee and then the employer, and it is within the jurisdiction of the labor arbiter or the NLRC, National Labor Relations Commission, then the arbitration is done by the government arbitrator or labor arbiter. ADR Act coverage governs voluntary, not compulsory. So the ADR Act governs voluntary ADR or arbitration. But compulsory arbitration is governed by like labor code and other laws that mandates arbitration before going to court. What are the kinds of arbitration? We have domestic, not international, international, foreign elements in parties and the issues or places of the execution of the contract, or foreign if the seat is outside the Philippines. So if the contract is outside the Philippines, so it involves foreign arbitration. Commercial arbitration covers commercial relationships like contracts. Said earlier, one example is if the Philippine National Police will buy firearms from a corporation in another country, then it is a commercial relationship. That should be covered by an arbitration clause. Governance, the law that governs arbitration in the Philippines, governed by Republic Act 876, Model Law, International by ADR Act, the implementing rules and regulation of the ADR Act, and foreign awards recognition by the ADR Act. Policy encourage for speedy, amicable resolution and is considered as wave of the future, as I said earlier. Arbitrator role, the arbitrator renders awards. He must be of legal age, no civil rights, literate. He can perform his civil rights, and he is literate and distinguished from arbiter bound by law or equity. Arbiter, like labor arbiter, different from arbitrator, who is a private citizen, but not a government arbiter. Not quasi-judicial, they are not part of the government, so it's not quasi-judicial, so they cannot be considered as a quasi-judicial agency or body or entity. And awards are not reviewable under Rule 43, because Rule 43 and Rule 65, they only cover arbitration conducted by government arbiters. But for awards by non-government mediators or arbitrators, the awards can be questioned only before the RTC through a particular petition, not through rules or petition under Rule 43 or 65, because Rule 43 governs petitions from petitions for certiorari on decisions or resolutions of government agencies, quasi-judicial agencies. Appointment by authority if parties fail and promotes efficiency. So the appointment of arbitrator should be by the parties. If not, it should be by a lawful authority, and it promotes efficiency. Now, what is the relevance of these topics to criminology students? ADR in criminal justice. It promotes restorative approaches in minor disputes like the barangay settlements and labor-related crimes. And it reduces adversarial conflicts. So it promotes amicable settlement or a friendly settlement. It encourages negotiation over confrontation and aligns with community policing and conflict resolution skills of law enforcers. And the key takeaway in ADR is that it supports fair, efficient justice systems, and it prevents escalation of disputes into more severe or serious crimes. So we settle first the minor issues, minor disputes, minor crimes before they become full-blown serious crimes. And let's discuss the two alternative dispute resolutions in courts. We have court annex mediation and the judicial dispute resolution. In CAM, or court annex mediation, is administered by the Philippine Mediation Center, whereas the judicial dispute resolution is conducted by a judge. The court annex mediation includes civil and criminal cases. So this is the one that is relevant to BS Criminology students. But for criminal cases covered by the court annex mediation, it only involves the mediation involving civil liability, not criminal liability. Because criminal liability cannot be uh, compromised when the case is already filed in court. Whereas JDR involves civil cases only. So we will concentrate or we'll focus on the court annex mediation. So what are the mediatable criminal cases in courts? So as I said, in the Philippines, cases that can be mediated or conciliated by the barangay are those cases that have imposable penalty of not more than 1 year, and those that have imposable penalty of a certain amount. I think it's 5,000 or 10,000. I forgot the figure, just check it out. So these cases will undergo mediation in court and conciliation or arbitration if the parties will choose or will decide that the barangay captain can arbitrate or decide their case, or the lupong or the pangkat can decide their case. So that's the arbitration. If not, then mediation, conciliation. If the dispute is not settled or resolved in the barangay justice system, the case will be filed in court. In court, in the court, there will be, for example, in criminal cases, there will be pre-trial. After pre-trial, the judge will can refer or shall refer the case. It is within the jurisdiction of the. It can be mediated. The court will refer the case to the Philippine Mediation Center for a court annexed mediation. So these are the mediatable criminal cases under the revised guidelines for continuous trial of criminal cases. First, crimes where payment may prevent criminal prosecution or may extinguish criminal liability, such as violations of the Batas Pambansa Bilang 22 or the law that governs bouncing checks. So if one person will issue a check but the bank account has no funds, so that's a violation of the BP 22. If the one who issued the check knew or should have known that the bank account had no funds, that's a violation of the BP 22 or the anti-bouncing checks law. But it can be mediated because this is a crime where the payment of money can extinguish or may extinguish criminal liability. Another violation of the SSS law, or for example, the employer has not remitted its contribution or the contribution of the employee to the SSS, then that's a violation of the SSS law. The same with the Pag-ibig law and other violations. So they can be mediated. Crimes against property. What are the crimes that can be mediated in court annex mediation? Like theft under RA 308. But theft involving property of not more than 12,000. If more than 12,000, it cannot be mediated because um, the penalty is higher, so it cannot be mediated anymore. So the penalty is not cognizable by the first level courts because the first level courts has jurisdiction on crimes that has imposable penalty of not more than 6 years. If more than 6 years, it is the RTC. And 12,000, more than 12,000 is cognizable, or stealing a property of more than 12,000 is cognizable by the RTC. Below 12,000, the theft is cognizable by the MTC, or Municipal Trial Court. Next is TAFA under Article 3151. Article 3151, no, except STAFA under Article 3152 and 3. 2 and 3, this involves fraudulent schemes, or that involves fraud. But 3151, it involves abuse of confidence. Like for example, if one person is selling rice, but while selling rice, he misrepresent a particular sack of rice as a particular good or excellent variety that is expensive, but he misrepresents it, meaning he dilutes the quality of the rice, he mix it with poor quality of rice, so the rice is not anymore that excellent, but he misrepresents it as an excellent variety of rice. So that's an abuse of confidence. Another one, if a person is entrusted with a property, for example, the person is allowed to borrow a property, but after borrowing the property, for example, a motorcycle or a laptop, for example, or a cell phone, he's allowed to borrow the cell phone, but he sold the cell phone to another person. So that's an abuse of confidence. So that's under under Article 315. It is mediatable. Next, other forms of swindling, like um, pretending to be the owner of a house and lot and falsifying the document and selling the house and lot. So that's estafa, swindling. Swindling of a minor, so deceiving a minor. So estafa involving a minor. The minor is the victim of swindling here. Other deceits, like for example, the manghuhula or fortune teller. The fortune teller will tell something. He will ask you for money in order to tell your future. So that's a deception because nobody can tell you your future. That's other deceits. So that's estafa under 318. Malicious mischief or destruction of property. That's mediatable. Next, crime against honor. They can be mediatable, where the liability may be civil in nature, like libel by means of writing, similar means under Article 355. They can be mediated because in libel, the courts may choose that the penalty is not imprisonment, um, only a fine or damages. Threatening to publish, offer to present such publication for a compensation under 356. Meaning, for example, if a newspaper will say that, oh, Congressman Juan de la Cruz, we will not publish this picture of you with your mistress if you pay us something. So that's threatening to publish. But if you do not pay us, we will publish your picture with your mistress. So that's threatening to publish, an offer to present such publication for compensation. Prohibited publication of acts referred to in the course of official proceedings. So in courts, for example, if a reporter will go to the court, will take a video secretly, then will publish that video while the direct examination, cross-examination, a particular victim or the offender is occurring, then that's prohibited publication of an official proceeding in court. That's just an example. There, the grave slander or grave oral defamation or serious and insulting nature. So, grave slander or defamation. Um, it is grave, so it can be mediated also. Grave slander. So, like, it's not libel. So, it's not a public statement that causes dishonor to a person. So, it's like It's not through writings, it's not through uh, social media, it's not through TV, radio, but personal. But there are persons who heard the slander or defamation. So that's grave slander. Simple slander and grave slander by deed or doing something that causes dishonor to a person through an act. So that's grave slander by deed. Simple slander by deed, so it's mediatable also. Incriminating an innocent person and intriguing against honor. So spreading misinformation about a person just to destroy his honor. So that's intriguing against honor. Libel under RA 10. Libel, this is cybercrime, cyber libel, where the liability may be civil in nature. See, criminal negligence, it is also mediatable. So reckless imprudence, something to damage property. So the liability may be civil in nature only, because the damage is only property. The damage thing is only a property, so it is mediatable. Next, intellectual property rights cases where the liability may be civil in nature, like for example, the Nike logo or Adidas. You take Adidas, you sew your, you get your sewing machine, you you create or make t-shirts, then you take the Adidas logo, put it in your t-shirts and sell it. So that's copyright infringement or trademark infringement. Then the liability is only civil in nature, then it's mediatable. The procedure, referral of the case for mediation to the Philippine Mediation Center by the court. It's only after the conduct of the arraignment in criminal cases and pre-trial. So the accused must be arraigned first. After arraignment, there will be pre-trial. After pre-trial, the court will order for the referral of the case. It is mandatory, by the way. Referral of the case to the Philippine Mediation Center or for the court annex mediation. So that if there is mediation, if there is settlement, agreement, then the case will be decided according to the agreement, and there will be no trial anymore. So it contributes to the declogging of the courts. The court shall serve the order of referral to the PMC or the Philippine Mediation Center unit immediately after the arraignment and the pretrial or preliminary conference of the case. Then the mediation shall be terminated within a non-extendable period of 30 days. So the mediation in the court annex mediation shall be terminated within 30 days from the date of referral by the court. After the lapse of the mediation period, if the mediation fails, then trial shall proceed. So there will be trial because all avenues for dispute resolution have already been resorted to, but still there's no mediation or conciliation that has been arrived by the parties. Then it's time for the formal trial to begin. So that's all for our introduction to alternative dispute resolution for BS Criminology students. Thank you and have a good day.